Hi, my name is Robert Shelley with Shelley Law, and my law firm assists physician practice owners with drafting employment contract and independent contractor agreements. Today I'm going to talk about how to create a strong independent contractor agreement for a physician practice. And this will be specifically towards physicians. Obviously, a physician practice could have an independent contractor relationship with PAs or NPs or other allied health professionals, but this will just be a 1099 position for a physician working with a clinic. So there are a number of factors that are important and kind of go into making a strong independent contractor agreement for a physician. And so let's kind of walk through those factors right now. First, there is a fine line between calling someone an independent contractor, but their actual job duties are that of an employee. The IRS releases a 20-factor test that kind of helps people determine whether someone is an employee or an independent contractor. I find many times an organization is very likely misclassified an employee as an independent contractor, mostly due to not having to pay benefits or employment tax. So you need to make certain this person that you're going to contract with is actually an independent contractor and doing independent contractor type duties. And so some of the factors that go into that: how much control you have over their schedule, what patients they see, what locations they're at, how you pay them, do you give them benefits, do you pay for their malpractice insurance, all of that will go into it. So if you are going to classify somebody and pay them via 1099, then the most important thing, I think, is compensation-wise, is not giving them a straight base salary. It doesn't make a lot of sense to me. So if you are contracted with a physician and classifying them as an independent contractor, but then just paying them a straight base salary, that doesn't jive. Now, if you're paying them per shift, that certainly would make sense, or an hourly rate as well. Or probably the safer choice for any practice is to pay them via a productivity percentage. So they would get, now in private practice, almost nobody uses RVUs, so it would most likely be done through net collections. So you would give them a percentage of net collections. And I think it's smart for a number of reasons. One, when they are paid via net collections, there's at least theoretically no absolute certain amount of work that they have to provide, and then they're only getting paid for the work that they do. There's no paid time off. There's none of that, which leans more towards an independent contractor. How much a percentage? Usually somewhere between 25 to 35 would make sense. It would depend upon kind of the, financial stability of the organization and how efficient they are and how much support staff is needed for that physician, but normally somewhere between 25 to 35% would make sense. And net collections would be all of the money the practice receives on behalf of the personally performed services of the physician. The next thing to think about would be restrictive covenants. So non-competes and non-solicits. Just because it's an independent contractor agreement doesn't mean that you can't include those two things. And for most practices, it's a smart thing to do. So there are, I think, probably different standards for what's considered a reasonable non-compete in one state versus another. There's a handful of states where non-competes are completely unenforceable. So you'll have to look into that first, is how do the courts view non-competes in the state that you're in? And then once you've determined that, crafting a reasonable non-compete. But you certainly, as a practice owner, would want both of those things, the non-solicit and non-competes. The non-solicit would basically prohibit the physician from actively soliciting employees to come with them, and then the patients as well. Next, malpractice insurance and benefits, I'll kind of lump it into one. If they are an independent contractor, you most likely should not be paying for any of those things. That clearly would kind of lean more towards an employment situation. I have seen some independent contractors where the practice will pay for their malpractice and that's it. They won't pay for anything else. No, health, vision, dental, disability, life, retirement, dues and fees for their license and DEA and that type of thing. So they would not pay for any of those things, but some will just pay for the malpractice insurance. And then lastly, notice. Kind of the whole point of an independent contractor agreement is it's kind of like easy in, easy out, meaning there's not a ton of strings attached, either to start the relationship or get out of it. Now, there has to be some kind of notice period for both parties when it comes to a healthcare provider, mostly for continuity of care. So, if you're in a practice and you have a physician scheduled a month out and they walk into your office one day and say, I quit, I'm not, well, you have an entire schedule of patients excuse me, that needs a provider. And so I would say at least 30 days would be the minimum amount that I'd want as a practice owner. More towards 60 or 90 would make more sense, but no more than 30 days. No less than 30 days. So those are some factors that go into making a strong independent contractor agreement for a physician from the practice side of things. If you have any questions or need a independent contractor agreement drafted, feel free to contact my law firm at the contact information below in the description. Or if you have any questions, you can leave those in the comments and I'll answer all of those as well. So anyway, thank you for watching the video. Take care.